Companies Act Section 38, Punishment for Personation for Acquisition of Securities. 1. Offences related to personation. Section 38 of the Companies Act outlines serious offences related to fraudulent activities involving the acquisition of securities. Specifically, this section addresses instances of personation a deceptive practice where an individual uses false identities or fictitious names to manipulate the process of acquiring or subscribing to securities. Such actions are not only fraudulent but also undermine the integrity of financial markets, and therefore, this provision mandates strict penalties under Section 447 for those found guilty of such offences. Key offences. A. Using a fictitious name to apply for securities. One of the primary offences under this section is the act of using a fictitious name when applying to a company for the acquisition or subscription of its securities. In such cases, the individual deliberately adopts a false identity in an attempt to obtain securities fraudulently, either for personal gain or to deceive the company and other stakeholders. For example, an individual may submit an application under a made-up name in order to acquire securities to which they are not entitled. This act is punishable under the law and is considered a severe form of deception that compromises the fairness of the securities market. B. Submitting multiple applications using different names. Another significant offense is when a person submits multiple applications for securities using different names or varying combinations of their name and surname. This act is typically done to increase the chances of acquiring a larger number of securities than would be allowed if only one legitimate application were submitted. By altering the name slightly or using different variations, the person is attempting to manipulate the system to gain an unfair advantage, essentially circumventing the rules in place to ensure equal and transparent access to securities. C. Inducing a company to allot or register securities using a fictitious name. In addition to submitting fraudulent applications, it is also an offense to induce a company either directly or indirectly to allot or register securities in the name of a fictitious person. This type of personation involves actively deceiving the company into believing that a non-existent individual is entitled to receive securities. Such fraudulent activity can have serious consequences for the company and its legitimate investors, as it skews the allocation of securities and creates false records within the company's financial reporting. Those engaging in such activities are liable for severe legal repercussions under Section 447, which addresses fraudulent actions in the context of company affairs. 2. Disclosure requirements. To further prevent and discourage fraudulent personation, Section 38 imposes strict disclosure requirements on companies. These requirements ensure that all parties involved in the issuance or acquisition of securities are fully aware of the legal consequences of engaging in fraudulent behavior. Prominent reproduction in prospectus. Every company that issues a prospectus to potential investors must include the provisions of Section 38 prominently in the document. The prospectus is a critical tool that provides investors with essential information about the company and its securities offering, and by including a clear warning about the penalties for personation, the company emphasizes the seriousness of engaging in fraudulent practices. This requirement ensures that all prospective investors are made aware of the consequences of using fictitious names or submitting multiple fraudulent applications. It serves as a deterrent to those who might otherwise attempt to manipulate the securities acquisition process through deception. Prominent reproduction in application forms. In addition to the prospectus, the provisions of Section 38 must also be reproduced in every application form for acquiring or subscribing to securities. This further ensures that potential applicants are fully informed about the illegality of submitting fraudulent applications and the consequences of such actions. By including these provisions directly on the application form, the company provides a clear and immediate reminder to applicants that any form of personation or deceit will be met with criminal action, including fines and imprisonment. 3. Court orders upon conviction. If an individual is found guilty of violating Section 38, the court is empowered to take specific actions to rectify the harm caused by the offense and to impose appropriate penalties on the convicted individual. Disgorgement orders. One of the key actions a court may take is to order disgorgement, which requires the convicted individual to return any financial gains they obtained through the fraudulent acquisition of securities. Disgorgement is intended to strip the wrongdoer of any profits or benefits derived from their illegal actions, ensuring that they do not retain any financial advantage from their deception. This penalty serves not only as a form of restitution for the harm caused but also as a deterrent to others who might consider engaging in similar fraudulent activities. Seizure and disposal of securities. In addition to disgorgement, the court may also order the seizure and disposal of any securities held by the convicted individual that were obtained through personation or fraudulent means. By seizing these securities, the court prevents the wrongdoer from benefiting from their illegal actions. The disposal of these securities may be carried out in a manner that ensures they are returned to the rightful parties or are otherwise dealt with in a way that mitigates the harm caused by the offense. 4. Allocation of disgorged funds. The funds obtained through disgorgement, as well as any proceeds from the disposal of seized securities, are not simply retained by the state or the court. Instead, they are directed toward a specific, socially beneficial purpose, namely, the Investor Education and Protection Fund. Purpose of the Investor Education and Protection Fund. The Investor Education and Protection Fund, EPF, is a special fund established under the Companies Act with the goal of promoting investor education and safeguarding the interests of investors. The funds credited to the EPF are used to support various initiatives aimed at improving financial literacy, educating investors about their rights and responsibilities, and providing protection to those who may be at risk of fraud or deception in the securities market. By directing disgorged funds to the EPF, the law ensures that the penalties imposed on wrongdoers are used in a constructive manner to benefit the broader investing public. This serves to further reinforce the importance of transparency and integrity in financial markets and helps to prevent future instances of fraud or deception.